Welcome to the Southwest Florida Real Estate Update hosted by the York Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, presented by leading experts in the field. Today's guest is Amber Mondock with Mondock Law.
Well, thank you, Amber, for coming on the show today. And let's just still talk about wills and trust and everything. But the people that are does not have a will, how would you recommend them going about it, or if they even need one?
Yeah, absolutely. And thank you, of course, for having me on the show today. So, really, virtually most people need wills. Age of majority in the state of Florida is 18. A lot of times we think of wills as being relevant to just the older generation, and that's not necessarily true because in that document we can do important planning, not just about who's to receive your assets, but also who's to take care of, for instance, your children. And sometimes the younger generation have a tendency not to remember that. As far as who needs a will, that's virtually going to be any individuals that have assets that aren't set up to transfer on death. So if we have maybe a woman with all her accounts that have beneficiary designations, she may not need a will in that instance because everything's set up to transfer contractually. However, if you own real estate, if you have any investments, whether that be additional real estate assets, investment accounts, brokerage accounts, any assets that do not have survivorship provisions are all subject to being administered under the will and your estate.
And how about to add to that, power of attorney and any medical forms that they might need?
Yeah, so a lot of times we focus on documents that are needed upon an individual's passing, which would be your will. Now, what you're referring to are documents that are needed during your lifetime.
Right.
So in the state of Florida, actually, power of attorney is effective upon execution. And that can be different from state to state. So it's very important if you're moving from one state to another, or maybe you're holding assets in multiple states, that we take that into consideration. Another document, though, that's often utilized would be your healthcare surrogate. That's virtually who can receive healthcare information and make healthcare decisions. With that, it's also optional if you elect to put in place, for instance, a living will, where you're directing your physician and your healthcare surrogate in the event you're determined to be mentally and physically incapacitated, and let's say you have a terminal condition, that your desire is to have them remove life support at that point.
Right. And what is the difference between a will and a trust and different types of trusts?
Yeah, so most people are familiar with the last will and testament. So what that does, it spells out who's to receive your assets and who's in charge of administering your estate. Whether or not it's relevant, as I mentioned earlier, we can also include, for instance, guardianship provisions if there's younger children still involved. Now, the biggest difference when we're talking about switching from just a simple will to a revocable trust is probate avoidance. So by setting up a revocable trust, think of it as a vehicle that can hold title to your assets. Now, that can be financial accounts, that can be real estate. You can even assign, if you own an interest in a LLC or a corporation, we can assign those membership or stock interests into the trust. And then anything in the trust, what it does, it effectively avoids probate administration. So even though you have a will in place, a lot of people think that's the end of it and it's not subject to court administration, but that's not true. So upon an individual's passing, that will has to be submitted to the probate court, and then all of the beneficiaries and the personal representative go through the formal probate court process. So generally, that revocable trust is utilized for the clients who have a desire to avoid probate administration.
And people moving here from out of state, how does that affect them if they had one done in another state?
Yeah, so first thought is, it's always a good idea to get your prior documents reviewed because there might be state-specific rules that could impact your documents. One's homestead in the state of Florida. So, that gives you the ability to qualify for the homestead tax exemption. There's also certain restrictions on how you can devise or give your homestead property at the time of your passing, which may not be in line with how the prior trust or wills are written. Another consideration would be just overall, if you're coming from a state that maybe is subject to state estate tax or inheritance tax, it's another checkmark box stating, hey, I'm now a resident of the state of Florida. I don't intend to go back to that state. It also becomes important too. So if we're holding real estate in, let's say, the state of Florida and the state of Pennsylvania, we want to make sure that makes sense. So in that instance, a revocable trust, maybe you had a will just from the state of Pennsylvania. Adding that revocable trust could be very prudent to that individual, because they're not only opening themselves up to probate in the state of Florida, they're opening themselves up to probate in another state. So normally if I have clients who hold assets in multiple states, that revocable trust becomes very important for the family or their beneficiaries, because it lessens the court administration and attorney's fees on the back end.
And how about if somebody passes away and they, the survivor, does anything change after that, or is it, do they need to update their will or trust?
It's always a good idea to look at it, think of it like a health check with the doctor.
Right.
We make sure we have the people that we want nominated still in their relative roles. Depending on how things are written, whenever I sit down with clients, I try to go through a contingency plan. So heaven forbid if somebody passed away, we probably already have an alternate in line to serve in lieu of the spouse, let's say, that passed. But situations change, so it's always good to revisit it. We may be able to do a minor update depending on if our roles or our nominations of who we want serving have changed at that point. Or we could look at it and say, we were already set up the plan for this, everything's okay.
And how about if that final person passes away and they leave it to their children, and it's in a trust, and when they sell their real estate and it closes, how do they disperse the funds? Which way?
Yeah, that's a common question that comes up. So basically, on a real estate transaction, whenever you go to disperse those final proceeds, they're supposed to be to the holder on title. So, if you and I are on the title, well, that can go to us individually. However, if it's an entity on the title, such as a revocable trust, they are supposed to disperse those proceeds to the name of the trust. Now, sometimes I see in the practice of real estate, if it's a revocable trust, the closing agent knows it's just, say it's my revocable trust, I'm the sole owner, it's looking through to me as the owner. There's some discretionary where they'll actually let an individual receive the proceeds. However, definitely if there's somebody who's passed and we're down to property being sold for the proceeds to be distributed out to the beneficiaries, it really is proper to go to the trust name, because you have to think too, at that point, that trust has its own tax ID. So during your lifetime, the trust is revocable. It looks through to the actual owner, and we just use the social security number. However, upon somebody's passing, that trust actually generates its own tax ID because it's now irrevocable. So it's different tax reporting as well.
So they should maybe open up an account prior, even if it's for $10?
Correct. So they can just establish a minor account in the name of the trust for the purposes of receiving those proceeds, and then once the proceeds are received, the trustee can proceed to distribute those funds out and close the account.
Can a person make some changes without seeing you to their will or trust on their own? Make some notes?
Make notes, yes. Make changes, no. So those need to be done in a formal written codicil or amendment in the state of Florida, and we have certain execution formalities too. You effectively just can't, handwrite and pencil in your changes on the trust or the will. Those won't be recognized.
Even if they're notarized, or they're on their deathbed and they want to make some changes?
So we don't recognize holographic wills, so that would not go over smoothly. Now, if, let's say, they're on their deathbed, we have a typed up document with their wishes and proper witnesses and notary formalities, then arguably it could be okay.
And how about if a person's going through a divorce and someone passes away and they do have a will or a trust, how's that affect them?
Yeah, so as far as divorces go, generally speaking, a lot of times the documents contemplate that. For instance, the power of attorney may state, in the event of the divorce proceeding being filed, that right for a person to step into that individual's shoes and take financial actions, that right's revoked. Under Florida statute too, if you get divorced, the presumption is that person should have been cut out of the plan, so therefore are treated as having failed to survive you. Now, sometimes people forget though, if you had a beneficiary designation on your bank account or your life insurance and you didn't switch that from prior spouse, well, that's going to pay out to the ex-spouse unless that's updated. So we may be covered under the estate plan. There may be changes that we need to make though, whether that be under respective documents or, how the assets are all set up.
How about a person that lives in another country and he's owned real estate here in the United States by himself, and then he gets married? How does that affect him if he sells his property here in the United States?
So as far as a foreign individual selling property, we need to look at the overall transaction because they could be subject to FERPA taxation. That's a 15% tax withholding from the seller's gross proceeds. So that could trigger additional taxation filing. As far as marital rights go too, we have to take into consideration where their domicile is. So if their domicile is still a foreign jurisdiction, let's say they maybe just own a piece of real property here. If spouse isn't on the title, we might want to add them to the title. Alternatively, a lot of my foreign clients, while we may not need to establish a full-blown trust or will or estate plan here, at a minimum, we can at least tailor the real property holding to pass via transfer on death documents. So Florida is one of those states in the United States that actually recognize an enhanced life estate deed. So what that deed does is effectively allow the individual to sell the property during lifetime, mortgage it, encumber it, lease it, do whatever you would do individually. But if they still own that property and they pass away, all we need to do is record a death certificate. So it simplifies their estate administration process in that regard, where we're just needing to record documents in the public records, and then the beneficiaries per se can step in, list the property, and get it sold.
Well, Amber, I've asked you a lot of questions. What else can you add that I haven't asked you?
Yeah, absolutely. So, I think it's important kind of where we started is estate planning isn't just for older individuals. It's relevant to younger individuals, basically anybody who owns assets that aren't subject to being payable on death, like I said, or people that have children too, that we need to ensure that their needs are being taken care of in the event something unforeseen happens. In Florida as well, if you're changing, state residency, it's important to look to our planning to ensure that we're set up in a proper manner. So we're transitioning over from one state to another state, and documents aren't being seen as invalid, or maybe they take extra legwork for a beneficiary to be able to administer the estate at the end of the day.
Well, I appreciate you coming on the show, and I know you've done my children and myself and some of my clients, and I highly recommend you call Amber if you have any questions on a trust or a will here in Naples. Thank you.
Thank you.